of the day, steel yourselves. This is construction products. And what we're proposing to do, I'm going to do a brief introduction, and then we'll have each of the panel members step up to the podium. They're going to introduce a particular aspect of the overall topic by reference to some slides, and then we will try to make this interactive, have an interactive finish. So construction products, it's worth remembering that construction products were subject to very scathing findings in the Grenfell Phase 2 report. See, for example, paragraph 2.19, which referred to failure speech marks of systematic dishonesty on the part of those who made or sold rain screen, cladding, panels, and insulation products. What we're going to hear in terms of panel members is we're going to hear about the relevant provisions of the BSA and how they allow claims for damages to be brought against product manufacturers and suppliers in respect of personal injuries, damages to property and or economic loss by anyone who has an interest in the dwelling and has suffered a loss as a result of the said dwelling being unfit for habitation. New provisions in the BSA don't just create new rights of action for building owners and leaseholders against manufacturers and suppliers, but may well come to the aid and assistance of defendant contractors and consultants, enabling them to pursue contribution claims, for example, against cladding manufacturers and suppliers who are responsible or may be responsible for the same damage. So, without further ado, we've got a series of panelists and presentations, and I think, Tom, you're up first.
Indeed, thank you, Simon. So before we get into some of the interesting points that arise in relation to the nitty-gritty of Section 149 claims themselves when they're being pursued, I'm going to start things off by looking at the role of contribution claims in this particular context, because it's claims for contribution under the 1978 Act, which had the ability to turn Section 149 from a weapon which can be wielded only by those who own the buildings into a tool which can be used by contractors, architects, and other construction professionals. So how does that work? Well, Section 1496 tells us that the only people who are actually given a cause of action under Section 149 are people with a relevant interest in relation to the relevant building. And relevant interest means someone who has a legal or equitable interest in the building or in one of the dwellings within the building. So you can only bring a claim for damages for Section 149 under Section 149 if you are a building owner. But that doesn't mean that you should only be interested in Section 149 if you're acting for or against a building owner. On the contrary, that's where contribution comes in, and contribution can potentially make 149 claims of much wider significance and importance. How does that work? Well, it's easiest to explain really by reference to some examples. Let's say you're acting for an architect. The architect has carried out the design of a new block of flats where the cladding is defective, has to be replaced. The owner in this scenario is the developer who appointed the architect in the first place to design the cladding. And the owner brings a claim against the architect saying that the cladding is defective, that's your fault, and we want the money from you for the remedial works. The architect in this scenario would like to pass on the claim to the cladding product manufacturer who produced the relevant product in the first place, or who made misleading statements about the product. But the architect obviously isn't someone that owns the building, so it can't bring a claim under Section 149 itself. But what it can do in this scenario is bring a claim for a contribution against the cladding product manufacturer. It can rely on Section 1 of the 1978 Act, and it can say, well, in this scenario, if the building owner's claim succeeds against me as the architect, I'll be liable for the cost of fixing the cladding. And you, Mr. Cladding Product Manufacturer, will also be liable to the building owner for the cost of the remedial works because of your defective cladding product. And so if his claim succeeds, you'll also be liable. I'm entitled to a contribution from you. So in that kind of scenario, we can see how the Contribution Act is potentially very powerful and can turn a claim that can only be brought by building owners into something that can be used by other designers, contractors, etc. However, contribution is not a panacea. There are limits to what it can do. And if we take a slightly different example, let's say here the building owner is bringing its same claim, defective cladding, against the main contractor, who was a design and build contractor. In turn, the DNB contractor passes on the claim to the architect whom it engaged to design the cladding in the first place. Again, our architect wants to pass on that claim to the cladding product manufacturer. But in this scenario, can it use the 1978 Contribution Act in order to do so? Answer, maybe not, because in this scenario, the damage which the architect's liability is to the main contractor, and the cladding manufacturer is not liable to the main contractor. Section 149 only makes the cladding manufacturer liable to the building owner. So on the face of it, a contribution argument isn't going to work like it did in our previous scenario, because the architect and the cladding manufacturer aren't liable to the same person. But we can peel back the onion a little further. There is another factor which has to be considered, and that's the role of the Defective Premises Act. So, layers on layers. If the works in question are ones to which Section 1 of the DPA applied, i.e. they involved the construction of a new dwelling or new dwellings, then Section 1 of the DPA would have imposed duties on all the contractors and construction professionals to see that their work and the works were fit for the dwellings were fit for habitation on completion. And in this sort of scenario indicated on the slides, even if the architect is only facing a claim from the main contractor as before, the architect might say, well, I'm liable to the building owner under the DPA. That's the red arrows on the slide. You, Mr. Cladding product manufacturer, are also liable to the building owner for the same damage, albeit pursuant to Section 149. That's the blue arrows. And so I want a contribution from you because we're liable for the same damage. Now, whether that kind of argument on contribution will get the architect home in this sort of scenario is perhaps an open question. Obviously, if in this scenario the building owner was bringing a claim against the architect itself under the DPA, that would be quite straightforward. That would be effectively equivalent to our first scenario. But the question is really, well, in this scenario, can a cladding manufacturer say, well, the building owner isn't bringing a claim against you. If you're found liable to the contractor, or you agree to pay money to the contractor to settle the claim, that's not a liability which I'm liable for. I'm only liable to the building owner. Possibly. Or can the architect say, no, it's sufficient that the building owner could have brought a claim against me, and say in settling the contractor's claim, I'm in substance discharging my very real liability to the building owner, and that's sufficient for a contribution claim. I think we'll have to see how those arguments play out. You can't give a definitive answer. Much will depend on the facts of a particular case and, for example, the terms of any settlement that might be entered into by, in this example, the architect. But what I think this does illustrate is that the scope for contractors and professionals to piggyback on Section 149 to make their own contribution claims is going to depend, to a significant degree anyway, on whether the cladding work involved either A, the construction of new dwellings, so that Section 1 of the DPA applies, or B, if it's just the overcladding of old existing dwellings, then the DPA or section 1 of the DPA isn't going to apply. And so some of the arguments that I've been talking about here aren't going to be available. And it does, certainly in my experience in a number of the cases I've been asked to look at in relation to this, it does often happen that one wants to bring a contribution claim based on section 149, but the person who's bringing a claim against you it isn't the building owner, it's someone else in the contractual chain. And that might be the main contractor, or it might be a project company in a PFI kind of scenario, or the sort of limited liability companies that local authorities often set up to contract on their behalf for that reasons, effectively. People who don't own the buildings, and so who don't have their own section 149 claims. And it might be for those reasons that in the government's construction products reform green paper, which was published in February of this year, and which I know you'll all be extremely familiar with, it might be, those sort of points might be why in that green paper the view was expressed that manufacturers, and I quote, have not made a fair contribution to the cost of replacing unsafe cladding and insulation products to date. And that's one of the reasons why the government's consulting on these points at the moment about, they say we're seeking to identify gaps and challenges in the current system. And so it's in that context that this works. I'd invite people to vote in relation to this question. Should the Building Safety Act be amended so that contractors and designers, as well as building owners, can claim against those who manufactured, marketed, or supplied cladding products? Please vote now. Well, let's hope that the government is listening to that. I think that's a resounding yes. Over to you, James, I think.
Or is it
Oh, sorry.
it's me?
Oh, apologies, Alex.
Right. I am going to start with a recap. Right, and I'm standing right in front of this, so I'm going to talk to you about the relevant sections so that you have context for what we're going to be discussing next. We're talking about section 149 of the Act. There are 4 conditions to be satisfied. It's a shopping list. Condition A is that there needs to be an inherently defective or otherwise problematic product. It's not on here, don't worry. Condition B is that the product needs to be attached to or included in the external wall. Condition C is that the building, including a dwelling, is unfit for habitation. Condition D is a causative link between your dodgy product and the unfitness for habitation. And that gives rise to E, which is a liability on the part of the person mentioned in condition A. There is a distinction to be made between section 149 and section 148. We are focusing on section 149. That relates to past defaults in respect of cladding products. Section 148 is prospective from the time the Act came into force, and that's wider. That relates to construction products, and that might create a significant difference. Now, obviously, with time constraints today, we can't deal with all of it, so we're focusing on the historic position in relation to cladding products. I'm going to be dealing with condition A, C, which is that a person manufactures a cladding product that is inherently defective, and condition B, which is that after condition A has been met, i.e. after the defective product has been manufactured, the cladding product is attached to or included in the external wall system. I have posed 4 questions, and we're going to have some audience participation in a minute. So, the first point, what's a cladding product in practical terms? Now, Section 149 subsection 12 gives us some assistance, and it says a cladding product means a cladding system or a component of a cladding system. Now, some of that's really easy. A cladding system is probably a sandwich panel or a glass spandrel panel, or maybe a proprietary brick slip system that's attached to some backing board. They're all the sorts of obvious composite products that we all deal with. A component is probably your dodgy insulation, a cavity barrier, possibly a metal rail fixing system, possibly an adhesive, and we're going to come back to adhesives in a moment. So some of these are going to be really, really easy to identify, but we need to remember we are only dealing with cladding products, not construction products more generally, because that's section 148. What about a ubiquitous product? A product that is manufactured not just for use in cladding systems. So I gave the example a moment ago about an adhesive. It might be used in cladding, it might not be. You've got a judgment call, I think, that needs to be made as to whether or not that falls within the definition of component of a cladding system. What might we look to decide that? Well, we might look to whether or not it was a product that was commonly used at the time in a cladding system. That might help us, and the answer there might be, if it was commonly used, probably is a component part. What if it was manufactured and the manufacturer produced literatures to say this is suitable for use in a cladding system? That might do. What about if an architect went off on a frolic of their own and came up with some sort of random system that included some sort of adhesive that wasn't commonly used in a cladding system? I think there might be a problem there. I think that might not fall within the definition of a cladding system or a component of a cladding system. So depending on the type of system that you're dealing with, there might be a judgment call that needs to be made. Next, who's a manufacturer? Well, when we're dealing with cladding, that's probably fairly obvious. It's the person who took the raw materials and meshed it around in a factory and produced the product. If we were dealing with different types of products, that might be a more complicated argument, but most of what we deal with is going to be a manufactured system. The difficulty is likely to be identifying who the manufacturer is, because we've all dealt with products where you might be lucky and you might have Kingspan labelled all over your insulation. That's easy, but that doesn't always happen. So 20 years on, you might struggle as a matter of practicality to identify who your manufacturer is to sue. The next question, what does inherently defective mean? And I'm going to ask you a question. There's no right or wrong answer to this, but I want a show of hands. Is Kingspan K15 inherently defective? Who says yes? There's no right or wrong, don't be afraid. Oh, right. Who says no? It's not inherently defective. Yes. So I think this is a really difficult question. I lean towards saying it's not inherently defective because you could use it below 18 metres. You could use it potentially as part of a fire engineered solution at the time, historically. We all know that when it's used in certain situations, if you haven't had a fire engineered solution, it is likely to be defective. But there is a difference between defective and inherently defective. And I agree, I think, with the majority of you who said it's not inherently defective. I think inherently defective captures products that are so obviously dodgy when they're manufactured. Something has gone wrong in the manufacturing process. Something is delaminated. Something has come apart. Something hasn't been heated up as it ought to have been to achieve the right temperature. That, I suspect, is what we're getting at here. What does attached or included in the external wall mean? So we're on condition B now. Now, it's really interesting. Section 148 has slightly different wording here. So section 148, which is the prospective one, which deals with construction products more generally, that doesn't just say attached to or included in, it also says applied to. And I was thinking about different products that might be applied to an external wall. What about render? That's not necessarily attached to anything. There's no railing system, there might not be any fixings. It's not necessarily included within it, if included in means included within. Render might just be layered on the top. That, I suspect, is applied to, but that is not included in section 149. So what you might see is very clever arguments about whether a particular product falls within, attached to, or included in. And I'm going to leave you with this thought. What's an external wall? Does anyone have a definition of an external wall? Does anyone want to tell me what they think an external wall is? Or is that because you're all asleep or because no one can define it? I think it's really hard to define what an external wall is. I'll give you a couple of examples. So, section 149.12 actually catches parts of a roof system. The wording is really convoluted, but I think it's supposed to catch dormer windows and that sort of thing in roofs. So basically, if it's an area that you can stand up in, that you commonly use, that falls within the definition for the active external wall. What about soffits? And I'm looking at one person in particular who I'm working with on a case, who we've got a question. Is a soffit part of an external wall? So a soffit, you can have soffits in different parts of a building. Often you have them above entryways, so they're not part of the roof. And lots of architects will tell you that doesn't comprise part of the external wall. That might have timber on it. Maybe that's inherently defective. What about layers within the external wall? OSB boarding. Does that form part of the external wall system? So I think there are real questions to answer. The Act is really poorly drafted, I think, in this regard, because it just doesn't define these things. And I think we're going to need some decisions from the court to help us with this.
So Alex is taking you through condition element A in condition A in section 1492. Sorry, element C, inherent defective. I'm going to focus on a different part of condition A, which is element A, which is that a person fails to comply with a cladding product requirement in relation to a cladding product. And that may seem readily understandable. And we've lost the title slides because we were limited on slide length. But my talk is really, the title I gave it was In Search of the Cladding Product Requirements, because it's another element of the Act, which when you try and look at it and analyse it and find a way through, try and feed out your claim, it's actually far more confused than you may think. And here's our final panel speaker, which I'm grateful for. I'm going to try and cover his talk in a minute as well. Welcome, Charlie. So the question I have for you is whether you think the building regulations, particularly B41 on external spread of fire, fall within cladding product requirement. I'm going to leave it there at perfect knife edge. So hopefully I'm going to answer that question. I don't have the confidence to include the question again at the end, so I'm just going to assume that by the end, all of you agree with me, and you'll find out what my view is in due course. So the obvious place to start then in the Act is the definition of a cladding product requirement. And that's set out on the slide, that it means in relation to the split in two ways, before or after IP completion day. And this is Brexit returning again, because IP completion day is the end of the Brexit transition period, so 31st of December 2020. So your dividing line, you can take that as your dividing line. Most claims, of course, are likely to be before IP completion day. So before IP completion day, it's a requirement relating to a cladding product under the 1991 regs or the 2011 regulations. If it's after IP completion day, you only have the 2011 regulations or the 2019 regulations. Now, it's perhaps understandable that Parliament took the approach of referring to existing regulations, but this is where the difficulties arise. So I'm going to try and go through each of the regulations in turn. So the first set of regulations is the 1991 regulations. And the definition of what the regulations are is section 147. So 1991 regulations means the construction product regulations. So we have a cladding products requirement in regulation 3.1. It's that a construction product, other than a minor part product, shall have such characteristics that the works in which it is to be incorporated, assembled, applied, or installed can, if properly designed and built, satisfy the essential requirements. So far, so good. Question then becomes, okay, what are the essential requirements? Well, we have them in regulation 2.1, bottom of the slide. They are requirements applicable to works which may influence the technical characteristics of a construction product as set out in terms of objectives in Annex 1 to the directive. Now, there's a few elements to unpack here. Where it says requirements applicable to the works, those are, in my reading, not then found in the regulations themselves. What the regulations themselves contain is the objectives. So you're looking then for requirements elsewhere applicable to the works which may influence the objectives. So we look then for the objectives, and we have these in Schedule 2 to the 1991 regulations, which reproduce Annex 1 of the directive. And in the introduction, which is very helpful in terms of how broadly it's written, you can see that it talks about products being fit for their intended use, and in this connection satisfy the following essential requirements. Again, that phrase essential requirements, where the works are subject to regulations containing such requirements. So again, making clear that those requirements you can look for elsewhere. Now, focusing on fire safety, the essential requirements you can find section 2, safety in the case of fire, which says that the construction works must be designed and built in such a way that in the event of an outbreak of fire, the load-bearing capacity can be assumed, the generation and spread of fire and smoke within the works are limited, and the spread of fire to neighbouring construction works is limited. Now, of course, those are very familiar in terms of functional requirement B41. That's also focusing on spread of fire over the walls and also over towards neighbouring buildings. So to go back to the question I started with, in which there was a split of views, my view is that Part B of the building regulations, particularly requirement B41, are requirements applicable to the works, and they may influence the technical characteristics of a construction product in terms of those objectives on the slide here, because they deal with the load-bearing capacity with the spread of fire. So under the 1991 regulations, I say yes, there is an argument, a reasonable argument, actually a good argument, that the building regulations apply. Obviously, as we set out at the start, there are two other sets of regulations which can contain cladding product requirements. The second one is the 2011 regulations. Now, these are EU regulations which focus on harmonisation between the EU, matters such as CE marking. And now, from what I can see, having looked through, it's difficult to see what, if any, requirements you would actually be cleaning out from these regs, but certainly I don't think there is a clear route to the building regulations. If anyone has a different view, I would welcome discussion afterwards. Similarly, for the other third set of regulations, the 2019 regulations, which have three elements really. One, it's amending the 2011 regulations post-Brexit, and two, amending the 2013 construction product regulations, and also amending tertiary legislation. And again, their focus is on EU-wide harmonisation, CE marking. So I don't think there's anything in there which is easy to grab onto for any sort of claim, but also I don't think you can get to the building regulations, or at least I haven't managed to get there yet. So in summary, four important points. One, finding the cladding product requirements is not clear, and probably will be something, and when these cases gets to court, the court will give a view on. Secondly, I think it's another area of the Act, and there are many, where amendments, clarifications would be helpful. Now, notwithstanding that, if before 31st of December 2020, I think there is a good argument that you can, and your cladding product requirements, get to the building regulations, which for the reasons Alexandra gave on inherently effective, it's going to be a much easier route for you to go down. And I should say that I have managed to plead it and have the defendant admit it, so I've at least got that far. Although hopefully they're not listening to this talk and amend tomorrow. Now, the final point I would say is that the lack of clarity on cladding product requirements is also there on construction product requirements in section 148. But as Tom mentioned earlier, there is at least there a green paper, and there's a prospect that the government may be putting forward new regulations or amendments which give more clarity as to what exactly these requirements mean, and therefore what we can claim under. So with that, I'll gratefully hand over to Charlie, who's dashed back and forth to join the group.
Sorry, I was late. In part, the reason for mentioning that is because what I was dealing with today was a CMC in the Grenfell litigation, and that's not just for the purpose of making myself look good. It's because today we were actually touching on at times some things that would bear on the question of the Section 149 remedy. And that makes my job a bit easier today because it allows me to be neutral in what I say and pose some questions for you without actually offering any answers. But the points that we're now going to discuss, if I can get to them. Is condition A and the provision here in relation to misleading statements. So we got on screen this provision, which I understand Alex took you through earlier, but we're concerned with subsection B, where a person who markets or supplies a cladding product makes a misleading statement in relation to it. And the next sort of requirement that we're then looking at is condition D, which is that the facts referred to in subsections 2A, B, or C were the cause or one of the causes of the building or dwelling being unfit for habitation. So, some points to think about in relation to this new remedy. I've given you 5 questions there. What does it mean to market or supply a cladding product? Because these are the people or the entities that are built. What does that actually mean in practice? And a few observations on that. The wording is broad, to market or supply. There's no sort of limit imposed on that. But supply to whom or how? Because we know that the remedy is picked up by the person with the relevant interest in the building, but it's not necessarily the same person to whom the supply was made, which I think is a point that Tom will have picked up on earlier as well. But we also know that we're talking about cladding products, and the definition for that is incredibly broad. It's a cladding system or any component of a cladding system. So we might be looking at the supply of a component that then gets put into a cladding system, and one entity supplies that component to another who then puts it into a cladding system, manufacturing something else that contains this component, and that system is then supplied onwards by the party manufacturing the system to a contractor who then applies it to an external wall. So we could have a very attenuated claim, potentially, with the person manufacturing a cladding component way down the contractual chain, somehow on one reading of this, being liable for the consequences of a building being unfit for habitation further down the line, assuming the causal requirements, if any, are met. So we're dealing with a potentially impressive or wide-ranging remedy, but the question really is it as wide-ranging as it seems? Because you've got marketing as well, which captures not just the people actually supplying it, but potentially intermediaries. And there'll be a question of who actually counts for that purpose. I mean, for example, accreditation bodies that put forward documentation that explain how a product is to be used, marketing that product in some way. Is that marketing for the purposes of this provision if a party so wanted to bring a claim in that connection? And I suggest there's going to be some questions at the extremes on these points, but probably marketing and supplying products are concepts we're familiar enough with from other areas of law that we'll be able to apply them properly. But where it gets maybe more interesting, questions 2 and 3, what is a statement and when will it be misleading? Now, we don't get any statutory definition here, and that's actually contrary to initial drafts of the legislation as they went through the Houses of Parliament. What we initially had was a draft that said a misleading statement was to be prescribed by the Secretary of State in regulations. So there was going to be some further regulations that dealt with that. And then we had some draft construction product regulations, which actually addressed what a misleading statement was, its substance, the type of statements that were intended to be called. But those have been withdrawn and nothing on that front has been enacted since. So we're sort of left with no help on that front. So the question is where might we get help from in understanding what constitutes a statement and when it will be misleading? There's a remedy in section 24 of the Building Safety Act, which deals with the offence of providing false or misleading information to the building safety regulator. And the explanatory notes for that provision talk about false information, both deliberately false and information that provides a false impression. So that remedy sounds quite broad, and the explanatory notes there are directly addressing not just something which is actually false, but something which creates a misleading impression, a false impression. And the question really is, well, does that give us any guidance to what a misleading statement is under section 149? And again, you can see both sides of it, different wording used, different explanatory notes, explaining what is meant for that provision. But on the other hand, if we're to read the statute altogether and take the meaning of this provision from its overall context, maybe it's relevant to look at section 24(1) and what that provides for. The next sort of broad point really is how close is the analogy of a misleading statement with the concept of misrepresentation that we're much more familiar with in everyday claims? Are we going to see the same sorts of divisions between statements of fact versus statements of opinion? Or is it going to be more akin to the tortious concept of misrepresentation, which is broader? Again, there's no limit on the wording. There's nothing to indicate such a limit. But where again might we get some help? Well, probably from other legislation that deals with similar concepts. We might look at that and see how the courts have interpreted that to decide how this is actually going to be applied in practice. And I think we've got a couple of other areas that you might want to go away and look at to see what the court's done. We've got a potential analogy with the Financial Services and Markets Act 2000, which deals with similar concepts. And you've got statutory liability created there for untrue or misleading statements and omissions in certain published information relating specifically to securities. And broadly, when the courts looked at those provisions, even though they don't use the express language of misrepresentation, they have interpreted it in the same way as the ordinary rules of misrepresentations you and I would see them at common law. You've got consumer regulations that also address similar concepts. And again, the approach of the court tends to be to look at that through the same lens, or at least to take and draw upon case law for misrepresentation generally. So I think if you're looking for a way to find out what constitutes a statement and when it might be seen as misleading, i.e. just false or a misleading impression only, how far does it go? You'll have to look potentially at those other areas as well. So, sort of drawing that together, and if the approach here of the court is the same, if it's to look broadly at the concept of misrepresentation to see how misleading statements should be applied, a question is, are we looking at, for example, something that is an express or implied statement? Does it cover implied statements, which gives a wrong impression to a recipient, a reasonable recipient, or from which that recipient might draw an incorrect inference? And if that's really just restating what a misrepresentation might be, are we looking at liability also for pure omissions? For example, an omission which doesn't render a statement false or misleading, as we might understand it, but that nonetheless doesn't provide the full picture. What about an ambiguous statement that wasn't necessarily understood in a false or misleading way? Does that count? Can that count on its own? Or what about a statement which is wrong or misleading in an immaterial way for the purposes of whether or not the cladding product was actually attached to the building? So, to summarise that, you've got potential help from the law of misrepresentation as we know it, Jim, and then also in relation to other statutes where similar concepts have been applied. But even then, we're left with lots of questions about what this is going to cover and what its extent truly is. Question 4. Is there a mental element? Are we dealing with intention? Does that count? Does that matter? And this is a question that keeps on cropping up in pleadings, including those by my learned friends on the table next to me. But there's no express provision in relation to section 149 as to intention. There's nothing that says anything about intention. So you could say that it's neutral. You could say actually it's not saying anything at all. But certainly there's nothing that indicates it is required. And we all know that you could mislead inadvertently. But does the concept of misleading, I asked, actually connote leading something, doing something deliberately in a way that makes somebody or a reasonable person act in a particular way? Does it actually imply or connote intention, the concept of misleading in the first place? And then we've got the sort of the broader legal question, if you like. Are the courts going to favour an interpretation that means that liability is not imposed if reasonable care was taken by the maker of the statement to ensure that it wasn't misleading? A sort of no-fault strict liability regime. Is that what we're dealing with? And there are lines of authority to the effect that one doesn't necessarily presume that Parliament is legislating to create a strict liability offence in a situation like this, where reasonable care could never have avoided the outcome. And it's a question that I leave open as to whether or not that is an approach that will be taken to section 149. And one question that might bear on that is whether it's relevant that section 149 expressly applies to past defaults. And the fact that it applies to past defaults, does that have any bearing on whether the question of reasonable care is relevant? Final question. What about causation? What causation requirement is there? Is that relevant at all? And this may have been picked up earlier, but it's an odd form of wording that's used, which is that the facts in section 149 2A, B or C were the cause or one of the causes of the building or dwelling being unfit for habitation. And to my mind, it's slightly strange to talk of a fact being a cause in this way, particularly as you've got 3 different potential candidates. But the question, the obvious question is it enough for the statement to have been an effective cause, i.e. a factual evidence of what happened? is all that's really necessary a contribution to the unfitness? And then you've got the second question, does there still need to be a legal cause? In other words, is remoteness relevant for the way in which the statement was received or acted upon? Are novus actus interveniens still relevant? And do you, in order to demonstrate such a cause, need to consider whether the party actually using the cladding product might have actually been aware of the problems that it now complains of, or ought to have been aware of those problems? I think you can't really describe a misleading statement as being a cause of anything unless it materially influences somebody. So I think we're likely to find reliance is required in some sense. But one question that's still left open and not dealt with under section 149 is, does there have to be reliance by the claimant themselves? And I ask, well, would the remedy have any teeth, and what would those teeth be if reliance by the claimant themselves was required? So there you are, there's a few questions posed and no answers provided. I'm going to sit down now where I think we've got